this case, Your Worship. He informed me that he would like to address the court, Your Worship.
At the court, please, Your Worship. Your Worship, just a brief background on when this request for documentation started. It should also show in Your Worship's record, Your Worship. On 14 June 2019, the accused, or myself on behalf of the accused, requested verbally from the prosecution, that being Applicant Zeta at that point in time, for further particulars on the matter for purposes of preparing for the trial, the hearing of this matter. That was bank statements of the complainant, between the period 1 March 2013 to 31 January 2016, which was pertinent to the case of the defense. The second was all invoices submitted by the accused to the complainant over that same period. There was no formal application for access to information. It was an agreement reached between the defense and the prosecution. On 14 June 2019, that very same day after court appearance here in this very same court, Your Worship, I addressed a letter to Applicant Zeta confirming exactly which documents the defense sought. Then, Your Worship, the matter was on 14 June postponed to 5 September for further particulars, for access to this document. On 5 September, the state didn't have the documents. The matter was postponed to 31 October, again for further particulars. That was 31 October 2019. Worship, on 31 October 2019, state still didn't provide the documents. The defense was patient and accepted yet another postponement of the matter. On that day, it would be on the 31st of October on your record, Your Worship, or the 22nd of January, I'm not sure, I think it's the 31st of October. The defense already raised this issue, the fact that we are still waiting for these documents. And on that day requested that it be marked final. However, I'm not sure if that was actually done, Your Worship. Then, Your Worship, on the 20th, my apologies. I'm indebted to you, Your Worship. On 22 January, my apologies, on 31 October, the matter was then again postponed to 29 January 2020. On 22 January 2020, we were invited by Applicant Zeta to his office to inspect 23 card boxes full of leverage files and documents. In those files, we did not obtain one bank statement as requested. All the files contained invoices, however completely irrelevant invoices submitted by all kinds of other staff of the complainant, and not one submitted by the accused. Applicant Zeta said he'll address the issue with the accused. We were back in court with the complainant, my apologies. We were back in court on 29 January. On that day, still, obviously we didn't receive documents, that being a mere 7 days after we inspected documents, which turned out not to be the correct documents at all. Matter was postponed on that day to the 26th of March, 2020, to the 31st of March. My apologies, Your Worship. But the matter was anticipated to 26 March by agreement between myself and Applicant Zeta, but on the basis of lockdown having started on the 27th, so we agreed to anticipate the matter and postpone it to today. And Your Worship, we are in this court again today, and we still don't have the documents. I understand Applicant Zeta is not here. It becomes a very comfortable excuse, I must state with respect, Your Worship. And the problem here is it's a prejudice at the end of the day to the accused, the defense. We've been here at every appearance, Your Worship. This would be, if we postpone this matter again today, it's remanded, it would be postponement number 5 for exactly the same thing. And that will also appear from your record. And every single appearance, the accused now has to pay legal costs to be here for no reason. Your Worship, I do submit that the accused should not be prejudiced in the way that the accused is prejudiced. and the request is for the matter to be struck from the roll. Your Worship, I submit there's no prejudice to the state for the matter being struck from the roll. It's just a benefit to the accused not having to pay legal costs over and over again and coming to court, Your Worship, for no reason. If the matter is struck from the roll, we all know very well the matter is not withdrawn. The charges are not withdrawn. The accused is entitled, the state's entitled to re-enroll the matter once they've got their affairs in order. And Your Worship, I submit once they've got these documents from the complainant, they can re-enroll the matter and we can proceed with the matter. That's all from us, Your Worship. That's the court, please.
Mr. Secretary, do you want any brief from Mr.
As the court, please, Your Worship, during the adjournment, I spoke to Advocate Zita, and then to get feedback from him as to the position of the case. He informs me that the problem, the information that the defense requests from him, he does not have that information at present. It is with the complainant's company. So he said they went to the complainant's place, the office, only to find that the office is closed because of lockdown. So that's the problem why they cannot get that requested information. My learned colleagues requested information because the complainant's offices are closed because of lockdown. That's the reason why they cannot furnish him with the requested information. And then Yoshua, he couldn't tell me, or he does not even know when, until how long will it last, the closure of the offices. Maybe until the lockdown, that he couldn't clarify me on. But he says it's not that they don't want to provide them with the requested information, it's because the office of the complainant is closed. As soon as they can have access to complainant's offices, they will definitely provide the defense with the requested information. So, but he told me he will request this honorable court to grant them a postponement so that they can provide the defense the requested information. It is not because they don't want to. So that is what the advocates that inform me, Worship, as far as the my learned colleague's request is concerned. So he reiterated that he requests the court to offer him or to give him a further postponement in order to fulfill the defense request.
I support this, thank you. Your Worship, with respect, now saying that the complainant's offices are locked and he couldn't have access to the complainant or get documents from the complainant. Your Worship, we've been waiting since 14 June. By now, they could really have supplied these documents. All the history of this matter shows is that we will be appearing at court over and over again, and they will still not have the documents. So the probability is quite high for us to come back to court again on a date already arranged, just for in case, Your Worship. With exactly the same thing. We'll be here at court again, and we'll postpone again. And we don't know how long, my learned colleague just mentioned it, we don't know how long this lockdown will last or how long the complainant will be closed. That just serves the case of what the accused is trying to make out. Which is for the matter then rather to be struck from the roll. There's no prejudice to the state. The only difficulty created by the matter being struck from the roll is the state now actually has to do some effort just to get a subpoena out to the accused again, to come back to court, but the charges are not withdrawn. Your Worship, with respect, I leave it in the hands of the courts, of course, Your Worship, but with respect, this matter ought to be struck from the roll. As the court pleases.
May I raise it, please? This is an application brought by the accused to the effect that this matter is struck from the roll because of the following reasons. Further particulars were orally requested Counsel, Mr. Zita, 2019. The following documents were required to be furnished to the defense. Was the bank statements of the company, the invoices which were issued by the accused. When the defense got no joy from the stage, they decided to formally request those documents in writing. On the 31st of October 2019, they finished with those documents. On the 22nd day, January 2020, the defense was invited to the State Council's chambers, where they were given 23 boxes full of documents. However, bank statements as well as the invoices issued by the accused were not in those 23 boxes. Today, Mr. Applicant stands in for Mr. Zita, State Applicant, and the states and the telephonically discussed with Mr. Zita. We informed him that those documents which are required by the defense are in possession of the complainant, whose offices are currently closed because of the COVID-19 pandemic. The defense attorney is of the view that the petition is traffic. The legislature, in section 342A of the Criminal Procedure Act, 51 of 1977, prescribes a procedure which should be adopted by a court if it is tried in the law. And the essential parts of this legislation is the following. A court before which criminal proceedings are pending shall investigate any delay in the completion of such proceedings which appears to the court to be unreasonable and which would cause substantial prejudice to the prosecution, the accused, or his legal advisor, or state witness, or a witness. In considering the question whether the delays are reasonable, the court shall consider the following factors: the duration of the delay, reasons advanced for the delay, whether any person can be blamed for the delay, the effect of the delay on the personal circumstances of the accused, the seriousness, extent or complexity of the charge or charges, actual or potential prejudice caused to the state of the defense and the jury, including a weakening of the quality of evidence, the possible death or disappearance or non-availability of witnesses, the loss of evidence, problems regarding the gathering of evidence, and considerations of the cost. The effect of the delay on the administration of justice, the adverse effect on the interest of the public or the victims in the event of the prosecution against the accused, or any other factor which in the opinion of the court ought to be taken into account. Those proceedings have to be formally brought before the court. It's not a matter of actually addressing the court from the bar. The defense or the respondent, which would be the state in this matter, should be given a reasonable opportunity also to respond, addressing court as to why the matter should not be struck in the law, or conceding to the matter being struck in the law, or the court reasoning on this question. The advice that the court will give to the defense is to bring a formal application in terms of the proceedings of state. And I'll explain this matter now. Find a date on which Mr. Zita and the defense attorney will be available in this court
That's the condition.
Extending method of
That's the maybe provisional execution.
provisional excuse for the judge.
All right. So number 1 this side, up to 8 that side, please. Mr. Matotsi Ramavunga. Mr. Mokadu Bwane. Mr. Malaba. Mr. Ramakosi. Sorry, Mr. Malaba first, then Mr. Ramakosi. Mr. Nesane. You will all right. Thank you, Worship. Case number SCCC 48 of 2020. The state against Mr. Matotsi, accused number 1. Mr. Ramavunga, accused number 2. Your Worship will note that Mr. accused number 3 that's in the charge sheet as well as the indictment is not present today. He will be joined next week. That's Mr. Truta. Accused number 4 present today is Mr. Mukudbu Bwane. Accused number 5 is Mr. Baba. Number 6 is Mr. Ramakosi. Accused number 7 Mr. Nesani. And accused number 8 Mr. Magula. The appearances are as follow. Presiding Officer Mr. Nemavidi, Prosecutor Advocate J.H. van der Merwe, Mr. Hansen for accused number 1, Mr. Creer for accused number 2, Mr. Kulu for accused number 4, Mr. Venter for accused number 5, Mr. Nechihawa for accused number 6, Mr. Nswane for accused number 7 and Mr. Krause for accused number 8. Your Worship, I've inquired from all parties present. It's not necessary for the use of an interpreter, so we'll proceed in English. As I indicated, the accused were arrested yesterday. I'm in possession of the J50s of all the accused. If so required by the court, I'm in a position to hand it up. Thank you. Your Worship, at this stage all the accused are in custody. The state is not going to oppose bail. The investigating officer, Lieutenant Colonel Schneller, prepared a statement for purposes of the application. It is going to be a Schedule 5 bail application. The charges are listed in the indictment attached to the charge sheet. The indictment has been provided to all of the legal representatives of the accused. They are aware of the charges leveled against their clients. So in line of that, if the court can maybe give guidance as to how we shall proceed with the application for bail.
Right, as a housekeeping, we are all aware of the fact that whoever is in this courtroom should be wearing a mask. Secondly, the restrictions are to the effect that social distancing should be observed. And that means that everyone has to ensure that whoever is next to them, there is a space of about 1.5 meters. The court is enjoined to enforce this type of law. And I see that on the eastern and southern side of the country, there are so many people who are not observing social distancing, and I'm not going to proceed in this court if this social distancing is not observed. I urge you, if you realize that you are too close to your neighbor, to whoever is next to you, can you just move out of the court in order that we proceed without this court having to call the officials who will enforce this. I'm going to adjourn for a moment to ensure that this is social distancing.
All right.
Ja, die kes is Pretoria sentraal. Wat ek net
Which one?
May I proceed as a court, please? In the Regional Court for the Regional Division of Gauteng, held at Palm Ridge, case number SCC 48 of 2020. In the matter between the State versus Tsepiwa Matotsi, statement in terms of the provisions of Section 6011B of the Criminal Procedure Act 51 of 1977. I, the undersigned, Tsepiwa Matotsi, do hereby make oath and state. I'm an adult male and a South African citizen with identity number 077 0718 5406082. I'm the applicant in this application in which I seek relief from this Honourable Court to be released on bail. I respectfully submit, as I will demonstrate herein, that the interests of justice permit my release on bail. In any event, the dictates of fairness and justice in view of the peculiar facts herein warrant that I should not be deprived of my liberty and that I should be released on bail. Paragraph 3. I depose to this affidavit out of my own free will and have not in any way been unduly influenced to depose hereto. The facts herein contained, save where expressly indicated to the contrary, are within my personal knowledge and belief and are both true and correct. Other application in terms of Section 6011B of Act 51 of 1977, in brackets the Act. Paragraph 5. The purpose of this affidavit is to provide the Honourable Court with my personal circumstances and to address the allegations levelled against me, in brackets insofar as they are known to me, as well as to address the factors to be considered by the above Honourable Court as contained in Sections 60, subsection 4 to Section 60, subsection 9 of the Act. Paragraph 6. I have been advised and understand that I bear the burden to show that the interests of justice permit my release and I am obliged to initiate this application. However, I will put factors before the Honourable Court to show that it is in the interests of justice to permit my release on bail. Paragraph 7. I state that the State will not be able to present any objective facts that it would not be in the interest of justice to grant me release on bail, despite the fact that I was rightfully detained. For this reason, I will hereunder deal with the events which occurred. The objective facts will not refute my version as it is the truth. Personal circumstances, paragraph 8. I'm currently unemployed as my estate has been finally sequestrated. I was, however, a registered chartered accountant but not able to work at this stage. I currently reside at 30 Green Street, Bryanston, Johannesburg, which address has been confirmed by law enforcement. I must submit that I will be moving to the following residential address on 26 June 2020, namely 6 Pitcairn Road, Blair Gowrie, Randburg, area code 2194, Johannesburg. The same address can be confirmed if same is required. Paragraph 9. I was born on 18 July 1977 and I have resided in the Republic of South Africa all my life, and I regard South Africa as my permanent place of residence. I have no intention to relocate to any other country as I love my country. I do not own any immovable assets in South Africa due to the fact that I have been declared insolvent. Paragraph 11. I do not own valuable movable assets as I permanently reside with my wife, Tabelo Grace Matotsi, who is providing for me at this stage. Paragraph 12. My friends and family reside in the Republic of South Africa. Paragraph 13. My professional occupation currently provides me with no income, as I am not in a position to practice at this time. Paragraph 14. I've been residing in the Greater Johannesburg area for the majority of my life and have been unemployed for a period of more than 2 years. Paragraph 15. I've never been convicted of a criminal offence. There are further no outstanding cases pending against me, and I can furthermore confirm that there are no other cases against me investigated by the SAPS other than this matter. Merits, paragraph 16. My legal representatives have explained the provisions of section 60 in brackets 11 in brackets B of the Act to me. I respectfully make the following submissions in this regard. 16.1. I have been informed that I am accused inter alia of racketeering, money laundering, fraud. 16.2. I'm advised that I do not have to deal with the merits of the case for purposes of the bail application. However, I believe that it is appropriate to explain why I am at this stage not prepared to deal with the merits. 16.2.1. I was arrested early yesterday morning and therefore have subsequently not had a proper opportunity to consult with my legal representatives. 16.2.3. I, at this stage, intend to enter a plea of not guilty on the charges listed above. 16.2.4. I intend to have my day in court in order to prove my innocence. 16.2.5. I have furthermore been advised, which advice I accept being correct, that dealing with any merits at this stage in light of the aforesaid can cause me unnecessary prejudice. Flight risk, paragraph 17. I will stand my trial should it proceed against me, and there is no possibility that I will even think of not standing my trial should there be one. I trust the South African legal system and that the facts will show why I acted in the way I did. Paragraph 18. In order to persuade the above honourable court that I should be released on bail, I provide the following additional facts and information in terms of section 60 of the Act. Heading at section 60, subsection 4A, read with section 60, subsection 5 of the Act. Paragraph 19. I do not know the identity of any witness upon whom the state will rely in order to attempt to prove a case against me. In any event, I have no intention to interfere with any witnesses, as I have no cause to do so, and I undertake not to do so. I maintain good relationships with people, and I bear no grudges against anyone. Paragraph 21. As previously stated, I have no previous convictions or pending cases against me. I also confirm that there is no cases being investigated by the SAPS against me other than this case. Paragraph 22. All documents pertaining to this matter which I had in my possession, I have already provided to my attorney, namely Hector Hansen from Hansen Incorporated Attorneys. I thus do not have any documents in my possession pertaining to this matter. Heading at section 60, subsection 4, subsection B. Read with section 60 in bracket 6 of the Act. I respectfully submit that the facts set out above support my contention that I do not constitute a flight risk. Paragraph 24. I do have a valid South African passport. I undertake to surrender same as a condition if I am permitted to be released on bail. Paragraph 25. I will be able to raise an appropriate amount to post as bail as contemplated in subsection 13A of the Act. Heading at section 60, subsection 4C, read with section 60, subsection 7 of the Act. Paragraph 26. I have no knowledge of any evidentiary material which may exist with regard to the allegations levelled against me. In any event, I believe that whatever such evidence may be, it is in the possession of the police, alternatively the National Prosecuting Authority. It is safely secured, and I do not have access thereto. I undertake not to interfere with any further investigations. Paragraph 27. I'm not sure which witnesses the state will rely upon in order to attempt to prove its case against me. Nonetheless, I undertake not to communicate with any witness, whoever he or she may be, and any other persons whose names may appear on a list of state witnesses to be provided by the state. Paragraph 28. During insolvency proceedings that include the sequestration of my estate and the liquidation of their investments, I at all times offered my full cooperation and subsequently made myself available to appointed curators, liquidators and others. This hopefully will constitute and or illustrate to the above honourable court that I am of the intention of giving my full cooperation, as I at all times have been advised to do so by my legal representatives. Paragraph 29. My continued incarceration can only prejudice me and my family and creates no benefit to the state. The prejudice referred to inter alia is duly examined in paragraphs 33 to 36 below. Heading at section 60, subsection 4D, read with section 60, subsection 8 of the Act. Paragraph 30. I have not at this stage, nor during my arrest, or at the time supplied any false information. Paragraph 31. It has been submitted that I have never been convicted on a previous conviction. Heading at section 60, subsection 4E, read with section 60, subsection 8, capital A. Paragraph 32. I respectfully submit that should I be released on bail, my release shall not disturb the public order or undermine the proper functioning of the criminal justice system. Heading at section 64, read with section 60, subsection 9 of the Act. Paragraph 33. It must be noted that I have been in custody for a period of 1 day since my arrest. Paragraph 34. I furthermore submit that I have recently been diagnosed with diabetes. Proof of same can be provided to the above honourable court in the event that same is required. I've been advised by my medical practitioners, and furthermore I've learned from medical articles published online that persons suffering from diabetes have a higher risk and or chance of dying from the COVID-19 virus. It is common cause that the said virus at this moment is a massive pandemic in our country, and I therefore submit that further incarceration will constitute a higher risk of contamination of the virus. Paragraph 35. I have furthermore been advised by my legal representatives that the trial proceedings that face me are not ordinary. The trial will be in enormous public interest. I have learned that the state has compiled massive volumes of evidence, and I will therefore need hundreds of hours of preparation with my legal representatives in order to properly prepare for trial. In the event that I am further incarcerated, I will subsequently be restricted access to my legal representatives to properly consult, peruse, and or prepare towards this very serious trial that stands before me. Paragraph 36. It must lastly be submitted that I am the father of 2 minor children, in brackets 6 and 9 years old respectively. I play a massive emotional and supportive role in their respective lives. Should I be further incarcerated until the conclusion of the trial proceedings, in brackets, which I have been advised will not be in the near future, conclude bracket, I will not be able to support my minor children whatsoever. Heading, conclusion, paragraph 37. I will comply with such conditions as the above honourable court may wish to impose. Paragraph 38. I accordingly submit that the interests of justice, considerations of prejudice, and the balancing of respective interests favour my release on bail. The court pleases your worship. Worship.
Do you confirm the contents of the affidavit in support of this application and read the document when you obtained it? Speak up.
Yes.
Affidavit, Mark.
I please you.
This case for the applicant.
That's the case for the applicant. My please you.
Confirm appearance on behalf of accused number 2 in this matter, Your Worship. Accused number 2 has also prepared a bail affidavit in this regard, and we beg and same up to Your Worship. So may I then proceed in reading the bail affidavit. In the Regional Court for the Regional Division of Gauteng, held at the Specialised Commercial Crime Court, Johannesburg, case number 48/2020, in the matter between Andile Malusi Atwell Lamavunga, the applicant, and the state. Affidavit in support of bail application. I, the undersigned, Andile Malusi Atwell Lamavunga, hereby declare under oath as follows. Paragraph 1. On the applicant in the above mentioned matter, an adult male aged 40, with the following personal particulars and background. 1.1. My identification number is 7910054362-084. I attach a copy hereto as Annexure AR1. 1.2. Date of birth. Was born on the 5th of October 1979. 1.3. Citizenship. I am a South African citizen by birth. 1.3.1. Travel documents. I'm the holder of 2 valid South African passports with passport numbers A023828873 and M00209 which passports will expire on the 12th of September 2022 and 14th February 2027 respectively. I attach here 2 copies of both passports as Annexure AR2 and Annexure AR3 respectively. I applied for a second passport whilst the other one was still valid, seeing that there were no further space in the initial passport for further entry and exit stamps. 1.3.2. previous travel or residence in foreign countries. I've never resided in a foreign country, but I have traveled to various destinations in the last 5 years for business and leisure purposes. These countries include Swaziland, Sudan, Namibia, the United Kingdom, the United States of America, Zimbabwe, the United Arab Emirates, Mauritius, Germany, and the Netherlands. 1.3.3 Relatives resident outside the Republic of South Africa. I do not have any direct relatives resident outside the Republic of South Africa. 1.3.4 Outside the Republic of South Africa. None. 1.4 Personal background. 1.4.1 Place of birth. I was born in Union Hospital situated in Alberton. 1.4.2 Schooling. I attended St. Francis College situated in Benoni, where I successfully completed grade 12 in 1996. 1.4.3 Tertiary or other training. I attended the University of Johannesburg from 1997 until 2001, where I successfully completed my BCom degree in accounting. I further attended the University of KwaZulu-Natal in 2002, where I successfully completed a postgraduate degree in accounting. 1.4.4 Work history. I was employed as the Chief Executive Officer at VBS Mutual Bank as from 2003 until March 2017, when the bank was placed under curatorship. My duties included, but was not limited to, the drafting and implementing the turnaround strategy of the bank, raising funding, stabilizing shareholder relationship, and managing relationships with regulators. From 2012 until 2013, I was employed at a small enterprise finance agency, CEFA, where I was employed as the Chief Financial Officer. My duties included, but was not limited to, drafting and implementing the finance, property, and procurement strategy, responsible for a staff completion of 18 people, responsible for the day-to-day operations of the finance, property, and procurement divisions, managing relationships with the Ministry of Economic Development, managing relationships with the IDC, the parent company, managing relationships with external auditors and the Auditor General, representing CEFA on boards of investor companies, and acting in the Chief Executive Officer's capacity when required. From 2010 until 2012, I was employed at Thala Limited as the Chief Operations Officer. My duties included, but was not limited to, the drafting and implementation of the bank's strategic direction, responsible for staff completion of 305 people, responsible for the day-to-day operations of the bank's distributors network across KwaZulu-Natal, managing relationships with clients and suppliers, managing government relationships, responsible for revenue budget of 200 million, responsible for an excess budget of 160 million, and representing Thala at stakeholder functions. From 2009 until 2010, I was employed at Land Bank of South Africa and as the Deputy Senior Finance Manager. My duties included, but was not limited to, the managing of a staff completion of 46 people, managing all business operations, daily, weekly, monthly, quarterly and annual functions of the Finance and Admin Department, managing external and internal reporting, formulating and managing financial processes, procedures and policies, managing an effective and cost-effective procurement process, compiling and managing operational and capital budgets, identifying and incorporating changes to generally accepted financial practices in the system, attending and participating in strategic decision-making of the bank, preparing input into the strategic documents of the bank to be presented to the Minister of Finance, and ensuring compliance with the PFMA. I was further also employed at Absa Bank and First National Bank. I completed my articles prior to thereto at Deloitte. 1.4.5 General remarks regarding background and permanency. I have no plans, immediate or in the future, to relocate anywhere else outside the Republic of South Africa. I have strong emotional ties to the Republic of South Africa and regard same as my permanent place of abode. 1.5 Current status. 1.5.1 Address. I reside at 401 Tilford Road, Cedar Creek Estate, Broad Acres, Fourways, Gauteng. I reside at the aforementioned property with my wife and my 2 children. I was arrested at the aforementioned address. 1.5.2 Marital status and general particulars of spouse. I am married to Zanele Msibi, who is a citizen of Swaziland. I've been married to her for 5 years and have been resident with her in Gauteng ever since we got married. 1.5.3 Dependents. My wife and I have 2 children who are respectively 4 and 2 years of age. Our children are wholly dependent upon my wife and I. 1.5.4 Occupation. I'm a self-employed as an entrepreneur. During my term at VBS Bank, I had other business interests and companies of which I was a director of. I'm still a director of various companies. 1.5.5 Income from occupation. I earn approximately 30,000 Rand per month after deductions. My wife and I are further reliant upon friends and family when further funds are required to ensure that all needs are met. 1.5.6 Immovable assets.
My wife and I jointly own the property situated at 35 Libra Avenue, Sundowner, Randburg, Gauteng. We own the aforementioned property, seeing that we are married in community of property. The aforementioned property, which is the only property registered in my name, currently vests in the trustees of my insolvent estate, which is subject to a petition which has been filed at the Supreme Court of Appeal with case number 242/2020. 1.5.8 Availability and sources of funds for bail. I can afford to pay bail in a reasonable amount. I have to pause at this junction and bring it to the court's attention that both my accounts, which I had with Investec and ABSA, have been frozen subsequent to the final sequestration order on the 23rd of August 2019. Paragraph 2, history of antisocial behavior. 2.1, previous convictions. I have no previous convictions. 2.2, pending criminal cases. I have no pending criminal cases. Paragraph 3, arrest and factual background thereto. 3.1, date of arrest. I was arrested on the 17th of June 2020 when various members of the South African Police Services arrived at my primary residence with a search and seizure warrant. I was arrested subsequent to the search and seizure warrant, which was performed by several members of the South African Police Services. 3.2, offences charged with. I've been informed that I'm charged with various offences being fraud, theft, corruption, money laundering and racketeering. 3.3, intended plea. I intend to enter a plea of not guilty against all charges preferred against me. 3.4, defence. It is common cause that an inquiry in terms of Section 136 of the Financial Sector Regulations Act, Act 9 of 2017, was held at Worksman's Attorneys in 2018, in which inquiry I testified. I gave my full cooperation since the inception of such inquiry, and I have ever since complied with due legal process whenever it was required of me. The well-known Terry Mattel report was released soon after the completion of the aforementioned inquiry with title, The Greatest Bank Heist. Mr. Mattel SC is the author of the report, and he was assisted by Worksman's attorneys, who also happened to be the attorneys, who was instructed to launch an urgent sequestration application against my wife and I in 2018. From the information in the public domain, such as the Mattel report and the sequestration proceedings, it is alleged that from at least 2017 until the appointment of the curator, Mr. A. Ruplal, on the 10th of March 2018, VBS fell prey to a fraudulent scheme of epic proportion, which has resulted in a loss of the bank of approximately 1.5 billion rand. It is further alleged that I was part and parcel in the execution of the alleged fraudulent scheme with other individuals. It was then further specifically alleged that I accepted a payment of 15 million rand, being a bonus from BEDE. I herewith yet again confirm that the 15 million rand bonus, which was referred to in the affidavit opposed to by Anish Ruplal in the sequestration proceedings, were in fact not a bonus, but rather monies received for services rendered by Dambale Holdings Pty Limited. The primary evidence upon which reliance is placed to assert that I was part and parcel of the fraudulent scheme is the affidavit furnished by one of the alleged co-perpetrators.
I've just gone through the affidavit which your attorney Mr. Kruger has given. You seem to be raising a defense in this affidavit. So I have to advise you first. The record of this being application shall form part of the record of the trial following upon such bail proceedings. If you elect to proceed using the route your attorney is following, this defense which you raise here may confront you during trial. Do you want this to go on record? You will consult with the people.
Thank you very much.
You will consult.
To confirm. And then proceed with it. Bishop, I will then just start off with the paragraph which I ended off with. I can't remember at which word I finalized that paragraph. The primary evidence upon which reliance is placed to assert that I was part and parcel of the fraudulent scheme is the affidavit furnished by one of the alleged co-perpetrators, Kopi Mukudubwana, to the investigators appointed by the South African Reserve Bank under Section 134 of the Financial Sector Regulations Act, Act 9 of 2017. The gist of my explanation for the receipt of the 15 million rand from Vele can be explained in that I'm a director of Dombale, of which the Zulu Trust is a 100% shareholder in Dombale. Vele appointed Dombale to structure and negotiate the purchase of the interest of one of Mr. Mshlanga's in Vulela Service Group. For effecting the successful purchase of Vulela by Vele, Dombale would receive an introductory fee of 2% and a success fee of 3% calculated on the 300 million which Vele would pay in acquiring those interests in Vulela Holdings. As a result of the successful purchase of those interests by Vele, Vele paid 15 million to Dombale. The 15 million payment was received by Dombale as remuneration for effecting the purchase of Vulela by Vele. I did not receive any money, Dombale did. There is no evidence to sustain a conclusion that I acted in concert with other alleged perpetrators so as to appropriate any monies. The aforementioned explanation was already in the public domain by 16 July 2018 when I deposed the sworn affidavit which forms part of the sequestration proceedings brought against me. In my answering affidavit, I explain in great detail that at no stage whatsoever was I a participant in the fraudulent scheme which I was allegedly a part of. I further stated that I do not bear any personal knowledge of the details of such alleged fraudulent scheme. I remain steady in my defence relating to the aforementioned allegations and yet again deny that I was part and parcel in the execution of an alleged fraudulent scheme with other individuals as alleged in the founding affidavit both by alleged Ruplal in the sequestration proceedings. I further vehemently deny that I ever perpetrated any fraudulent act against VBS Mutual Bank or anyone else and further put the state to prove the contrary. I have further cooperated with the trustees of my insolvent estate and have since the 23rd of August 2019, when the estate of my wife and I was placed under final sequestration, attended to all inquiries held in terms of Section 152 of the Insolvency Act. I can further confirm that I voluntarily initiated correspondence through my attorneys of record, David H. Botha, Du Plessis and Kruger, by writing to the National Prosecuting Authority as well as to the Directorate of Priority Crime Investigations on the 19th of November 2019. In the same correspondence, it was made clear that I'm uncertain as to whether or not there's any criminal investigations pending against me. I further made it clear that should there be such investigations pending, I would be willing to cooperate with due legal process and would further be willing to report to the authorities to facilitate same, even if it was to subject myself to an arrest. It was also mentioned by my attorneys of record that they are of the opinion that such appearance should be effected by means of a J175 summons and not an arrest due to the history of this matter. The same letter was transmitted to Mrs. Cronje from the National Prosecuting Authority on the 25th of November 2019. I attached letters here to mark as Annexure AR4 and AR5 respectively. My attorneys of record received a response from the officers of the National Prosecuting Authority on the 25th of November 2019, in which correspondence they confirmed receipt of the correspondence of the 19th of November 2019. It was further made clear in the letter that my correspondence of the 19th of November 2019 would be provided to Applicant George Baloy, the Acting Director of Public Prosecutions North Gauteng, Pretoria, for him to consider. The correspondence is attached here to as Annexure AR6. My attorneys of record transmitted further correspondence to the email addresses as provided by the National Prosecuting Authority in their correspondence of the 25th of November 2019, in which correspondence my attorneys of record requested that they be provided the contact details of Applicant George Baloy to determine whether or not there are any pending criminal investigations, and in addition whether my attorneys can assist with anything. The email correspondence is attached here to as AR7. No response was subsequently forthcoming from the National Prosecuting Authority. Paragraph 4. Submissions regarding factors to be considered when deciding whether bail should be granted. 4.1. Schedule of Criminal Procedure Act 51, 1977. Matter resorts under. I've been advised that the offence that I'm being charged with falls under Schedule 5 of the Criminal Procedure Act. 4.2. Considerations in terms of Section 60, 4, A to E. 4.2.1. Section 60, subsection 4A. Danger to public or individual safety. I respectfully submit that my release on bail will not endanger any person's safety. My personal profile as set out here and above clearly shows that I'm not a person with a disposition to violence. I harbour no resentment towards any particular individual or to the public in general. I've not displayed any inclination to commit violent crimes through my previous conduct. I've not displayed any disposition to commit offences referred to in Schedule 1, as is clear from my profile. In addition, I've never committed a Schedule 1 offence while I was released on bail. 4.2.2, Section 60, subsection 4B, likelihood of evasion of trial. I would respectfully submit that this likelihood does not exist. I do not wish to evade my trial and live the life of a fugitive. I cannot afford to forfeit any amount that might be set as bail. I further have my family and career, which factors tie me to the area in addition to the fact that I've lived in the area my entire life. I further undertake to adhere to any bail conditions that the court might deem fit to impose. 4.2.3, section 64, subsection C, interference with witnesses or evidence. I respectfully submit that there is no likelihood that I would interfere with any of the state witnesses. I do not have any insight as to the exact allegations against me. I do not know what stage the investigations are, and I furthermore do not have access to the evidentiary material held by the investigating officer. I have no knowledge as to the identity of the prospective witnesses that the state intend to call, and in the event that their identity should become known to me, I would not interfere or attempt to intimidate them due to the fact that I intend to stand my trial and clear my name against all allegations which might tarnish my good name. 4.2.4, section 60, subsection 4D, jeopardy to the functioning of the criminal justice system or bail system. I would submit that I do not pose any danger to the functioning of the criminal justice system or bail system. I have not furnished any false information at the time of my arrest or for purposes of these proceedings. Paragraph 4.2.5, section 60, subsection 4E, exceptional circumstances present or absent, which may lead to the undermining of public order or peace. I respectfully submit that there are no exceptional circumstances which may lead to the undermining public order or peace should the court decide to grant me bail in this matter. 4.2.6, the provisions of section 60, subsection 9, the interest of justice in relation to the right to be released on bail. I respectfully submit that I will be prejudiced in the event of being further detained and that the conditions in prison are most important. In this regard, I request the Honourable Court to consider that I am not a flight risk, that I have no desire to abscond or evade my trial, as it is my intention to stand my trial and clear my name. I further urge the Court to consider the period that I am to be detained until this matter reaches finalisation, and the fact that criminal trials can take a considerable period of time before finalisation. Apart from the fact that the period of detention cannot be estimated with any form of precision at the moment, I humbly request the Honourable Court to take into account that I will not earn any income while so detained and therefore stand to suffer considerable financial loss. I'll also urge upon the Honourable Court that should I be detained and refuse bail, that I would be severely prejudiced in the preparation of my defence. It is extremely difficult to consult with a legal practitioner from inside prison, and I have no doubt that my continued detention will seriously jeopardise my preparation for trial. 4.2.7, other relevant factors to be considered by court. I respectfully submit that the interests of justice permit my release on bail, and that I am therefore entitled to be admitted to bail. I submit that the following facts in totality constitute that I should be released on bail. As I have stated herein above, I do not intend to evade my trial. I have several factors that tie me to the province of Gauteng, such as my family, my relationship with my friends and community. I'm not in flight risk due to the fact that I cannot afford the lifestyle of a fugitive. I'm not in the financial position to be able to forfeit any amount that might be set as bail. I submit further that I'm willing to abide by any condition the court may deem fit to impose. It is further my belief and submission to the court that should this matter proceed to trial, I will be in a position to clear my name of these allegations. I respectfully submit that, taken into consideration separately and cumulatively, all factors mentioned herein above, I have satisfied my burden of providing that the interests of justice clearly permit my admission to bail. Paragraph 5. In the premise and taking into account the relevant schedule of the charges resolved under, I respectfully submit that the court should grant me bail in the amount appropriate and within such conditions as the court may deem fit. And it has been deposed and commissioned this morning, Your Worship.
Do you confirm the contents of the applicant in support of the application which was already included in the agenda?
I confirm.
Accepted and matched the
That's the case for the applicant. That's correct, Your Worship. Thank you very much.
As the court pleases, Your Worship, firstly, if I may apologize for not having introduced myself.
I appreciate
Thank you, Your Worship. There was a lot of running around. I'm not familiar with the surroundings. Thank you very much, Your Worship. On behalf of accused number 4, Mr. Kobodwane. Statement was prepared, signed by Mr. Kobodwane. If I may have leave, Your Worship, to read this into the record. In the magistrate's court for the magisterial districts of That is the original commission. Oh, I'm sorry, Russia. It's a specialized commercial. Thank you, Worship, for the correction. As the heading, I'll make the amendment. In the matter between the state and Poppy Nkobodwane, accused, statement in terms of the provisions of Section 62B of the Criminal Procedure Act 51 of 1977. I, the undersigned Poppy Nkobodwane, do hereby make oath and state I'm an adult male and a South African citizen with identity number 84112552818082. I am the applicant in this application, in which I seek relief from this honorable court to reduce the amount as requested by the state in the amount of 100,000 rand, in brackets, the bail amount. I respectfully submit, as I will demonstrate herein, that the interest of justice to lower the amount, the bail amount, and in any event, the dictates of fairness and justice in view of the facts herein warrants that the bail amount is excessive. I make this affidavit of my own free will and have not in any way been unduly influenced to depose thereto. The facts herein contained are true and correct and are, save where the contrary is indicated, within my personal knowledge. The allegations set out below, which constitute legal submissions, are based on advice received from my legal representative, and I verily believe such advice to be true, to be correct, sorry. At application in terms of Section 62B(a) and B, Roman figure 1 and Roman figure 2 of the Criminal Procedure Act 51 of 1977, the Act. The purpose of this affidavit is to provide the above honorable court with my personal circumstances, as well as address the factors to be considered by the above honorable court as contained in Section 60 of the Act. I've been advised, and I understand that I bear the burden to show that the interest of justice permits my release as a reasonable amount, and that I am obliged to initiate this application. Personal circumstances. I'm a businessman and I reside at 29 Bedford Road, Bryanston, Johannesburg. I hold a BCom degree, specializing in investment management and corporate investment banking. I have resided in the Republic of South Africa all my life, and I have frequently traveled abroad for work and leisure. I regard South Africa as my permanent place of residence. I worked as head of treasury for VBS Mutual Bank, bracket VBS, for the period of from the period 8 August 2016 to 22 May 2018. Following an investigation into large scale of fraud and theft by executive VBS launched sequestration proceedings against me in South Gauteng High Court under case number 25058 of 2018. The matter was heard before Judge Dr. J. A provisional sequestration was ordered against me on the 1st of August 2018 and made final on the 28th of November 2020. I'm sorry, this is 2019. I'll make the amendment. My insolvent estate was registered with Masters of the High Court under reference number G779 of 2018 and Harvard Corporate Rescue Services and honey attorneys were appointed as joint provisional liquidators to the estate. The sequestration is exacerbated by the fact that I am currently unemployed and I'm completely dependent upon family to assist with legal fees and bail. Flight risk. I will stand my trial should it proceed against me. I trust the South African legal system and that the facts will show that I'm not guilty of the accusations leveled against me. In order to persuade the above honorable court, further, I provide the following additional facts and information in terms of Section 60 of the Act. At Section 62B and B, Roman figure 1 and Roman figure 2 of the Act. Section 62BA provides that 2BA, if the court is satisfied that the interest of justice permits release of an accused on bail as provided in subsection 1, and if payment of sum of money is to be considered as a condition of bail, the court must hold a separate inquiry into the ability of the accused to pay the sum of money being considered or any appropriate sum. B, if after an inquiry referred to in A, is found that accused is 1, unable to pay any sum of money, the court must consider setting appropriate conditions that do not include an amount of money for the release of accused on bail, or must consider the release of the accused in terms of guarantee as provided for in subsection 15 of B and or 2, able to pay a sum of money. The court must consider certain conditions for the release of the accused on bail and sum of money which is appropriate in the circumstances. I respectfully submit that consideration of my personal circumstances as aforementioned, that the bail amount as required by the state is not appropriate. It is my further respectful submission that should bail for me be set in the amount required by the state, that it will effectively amount to refusal of bail for me, as I'm only able to raise, with assistance of family and friends, the amount of 20,000 rand, in bracket, 20,000 rand, close bracket. The constitutional right to be released on bail will become meaningless where an excessive amount is fixed. Author Staler in Constitutional Criminal Procedure Act 1998 at 145 notes that an excessive bail amount is an indirect and unconstitutional way ordering the further detention of an accused. See also State versus Jacobs, 2011, Volume 1, SACR 490, ECP at paragraph 10, and see furthermore State versus Betani, 2007, Volume 2, SACR 590, at para 10, where Jafta JA, as it then was said, fixing bail at an excessive amount in a case involving a poor person such as the present appellant is tantamount to a refusal of bail. At section 64A, review section 65 of 60 sub 5 of the Act. I do know the identity. I do not know the identity of any witnesses upon whom the state will rely in order to attempt to prove a case against me. In any event, I have no intention to interfere with any witnesses, as I have no cause to do so, and I undertake not to do so. I have no previous convictions. I have not been released on bail pending any charges. I'm not disposed to violence. Act Section 64, read with Section 66 of the Act. I respectfully submit that the facts set out above support my contention that I do not constitute a flight risk, whereas I'm in possession of a South African passport. I'm not in possession of any other travel documents and undertake not to apply for such documentation pending the finalization of these proceedings. I do not have the financial means to travel to any other country as detailed above. South African borders remain closed for travel between countries in consideration of COVID-19 pandemic. In addition, I'm willing to surrender my passport to the investigating officer should it be a condition of bail. At Section 64, read with Section 67 of the Act, I have no knowledge of any evidential material which may exist with regard to the allegations leveled against me. In any event, I believe that whatever such evidence may be, it is in the possession of the police, it is safely secured, and I do not have access thereto. I undertake not to interfere with any further investigations. I'm not sure which witnesses the state will rely upon in order to attempt to prove its case against me. Nonetheless, I undertake not to communicate with any witnesses, whoever he or she may be, and any other person whose names may appear on a list of state witnesses to be provided by the state. At Section 64E, read with Section 68A of the Act, I respectfully submit that I'll be released. Should I be released on bail, my release shall not disturb the public order or undermine the proper functioning of the criminal justice system. In conclusion, I will comply with such conditions as the above honorable court may wish to impose. I accordingly submit that the interests of justice, consideration of prejudice, and the balancing of respective interests favor my release on bail. I further respectfully submit that a proper case has been made out for my bail to be fixed in the amount of 20,000 rands. 20,000 rands in bracket, as a result of my personal circumstances as detailed above. Signed, Poppy Londelani Nkobodwana. Thank you, Yoshi.
Do you confirm the contents of the affidavit in support of the application as read and noted by your
Yes, I do.
affidavit accepted and not received?
As the court business resolution, that is the case for the applicant. Thank you.
Mr. Kaplan?
I confirm my appearance on behalf of the accused number 5, Mr. Malaba. His wish to be placed on record, I'm Applicant Fenter, instructed by Rogers Levashonda to initiate. With the legal of the court, Your Worship, may I proceed to read into the record the bail application?
Yeah, let me go.
Yes.
You have joined in the original application.
Yes, Your Worship, if I may hand that up. Your Worship, I do apologize. Unfortunately, it's handwritten, filled in. I've been briefed it very late, Your Worship. So if there's any unclarity on my handwriting, please help me to accept it. In the Specialized Commercial Crimes Court for the region of Ekurhuleni Central, held at Palm Ridge, case number ACC C48 of 20. Support bail application information supplied by the accused under oath. I, Infantla, Kelvin Sipo Malaba, do hereby declare under oath as follows. Paragraph 1. I was informed by the court that anything that I might testify during bail proceedings may be used in my trial against me. I understand and accept it. My full names and surname as stated above is correct, and my identity number is 73050262460088. Paragraph 2. I do have a passport bearing number M00254567. I use my passport for the following reasons. Mainly for holidays, and during March this year I went to Botswana for a wedding, and I traveled approximately plus minus twice per year outside the Republic of South Africa, and I confirmed that I've handed my passport to the investigating officer this morning through my legal representative. Paragraph 3. I'm a citizen of South Africa since 2002, and my permanent residential address since 2010 is 708 Paddock Close, Fourways, and my cell phone number is 063-140-7577. My permanent work address since 2019 is 708 Paddock Close, Fourways. Paragraph 5. My profession is I'm a chartered accountant and I am self-employed. I currently use my cell phone as the cell phone number for the number for my business. Paragraph 6. Confirm that I am married. My wife's name is Jacqueline Malaba. And her telephone number is 073-649-4814. My wife is also currently self-employed. Paragraph 7. I have 3 dependent children who live at 708 Paddock Close, Fourways, of which 2 are scholars and 1 a student at UCT. My monthly gross income is 25,000 and my net 18,000. Paragraph 8. I'm the registered owner of the following movable property, namely a Land Rover Discovery valued at around 300,000 Rand, an Audi A3, which the value is unknown, an Audi A1, the value also unknown. Paragraph 8, subsection 1. I confirm I have no previous convictions or any pending cases or charges against me, and therefore I am a first offender. Paragraph 9. I respectfully submit that my release is going to be in the interest of justice for the following reasons. 9.1. That I will not disturb the public order or undermine the public peace and security. 9.2. That it is not my intention whatsoever to hinder the investigations in this case and or interfere with the investigating officer and or make the arrest of further suspects in this case impossible. Further, or commit any further offences of a similar nature like the one I have been charged with and or abscond and not stand my trial. Paragraph 9.3. I will under no circumstances whatsoever direct or indirectly interfere with the police investigation or hinder such investigation. 9.4. I will not attempt in any manner to influence or intimidate witnesses in this matter. I will further not attempt to destroy any evidence in this matter and or prevent witnesses to come and testify. 9.5. I will in no manner whatsoever undermine the objects or the proper functioning of the justice system, including the bail system, or place such in danger. Paragraph 9.6. I will assist the police in their investigation through my legal representatives as much as possible as I can, and will subject myself to the advice of my legal representatives in this regard. Paragraph 9.7. I will attend my trial and remain present until finalization of this case against me. 9.8. I will not flee or leave the Republic of South Africa due to the fact that I have a responsibility towards myself and my family, which depend on me for maintenance. 9.9. I will satisfy no matter how strict the conditions set by this Honourable Court concerning the bail condition. I will subject myself to these, though I am told and trust so, that it is necessary, that it means that I will have to report at a specified police office or police station daily, but it would include that I be restricted to a specified area and I would not be allowed to leave the area without the permission of a person allocated by the Honourable Court. Paragraph 9.10. I understand not to interfere or communicate with any state witnesses in this case. Presently, there are no names and or addresses known to me. The state will make such names available to me if the state is of the opinion that I would possibly know the names of the state witnesses. And 9.11, I did not interfere and or frustrate the administration of justice. Particularly, I did not in any manner resist or hinder my arrest. I understand not to interfere or attempt to frustrate the administration of justice. Presently, I have no knowledge of the identity of witnesses. If such names can be brought to my knowledge, I undertake not in any manner make contact with the state witnesses. 9.12. I undertake to hand in my passport or travel document, whether expired or valid, which is in my possession or in my control immediately to the Honourable Court, or hand such over to the investigating officer of the court after the Honourable Court has granted me bail. I have no previous convictions for defeating the ends of justice, and I undertake not to interfere with the state witnesses and or the police investigation. 9.14. I am told and trust indeed that my family and friends will contribute towards the payment of the bail, which may be set by the Honourable Court. I will also avail my own funds for payment of bail, which may be set by the Honourable Court. Due to my financial state, I am in a position to pay an amount of 10,000 rand for bail, but I am however told and believe, and indeed believe, the bail amount falls entirely in the discretion of the Honourable Court. Paragraph 10. I further confirm the following. My financial position, I am self-employed and trying to build a business. 10.2. My health is good. 10.3. My family and dependents are my children, my wife, and my mother aged 71. 10.4. The threat of COVID-19, especially during this time, may lead to certain prejudice suffered by me should I remain in custody. I also have a responsibility to maintain my family. Also, my continued incarceration will lead to severe prejudice to myself, and considering this matter and the complexity thereof, I will need sufficient time to prepare with my legal representative. Paragraph 11. I am prepared to comply with the above conditions should I be released on bail. This stated at Palmridge on this day, the 18th of June 2020, signed by my legal representative and the accused and Commissioner of Post Leadership. That's fine.
Do you confirm the contents of the applicant? Thank you. Which was already Applicant is accepted and not
As for future. That is the case.
Good morning, Your Worship. Applicant Neshaba, on the instruction of Manzula attorneys, on behalf of accused applicant number 6, Mr. Abashoni Ramikosi, we have prepared an affidavit, and if you please the court, my handing the original to the court. As please court. May I proceed to read the affidavit into records? Hello? In the Specialized Commercial Crime Court for the Regional Division of South Gauteng, held at Palmridge, in the matter between Abashoni Parapara Ramikosi being the applicant and the state as the respondent, affidavit in support of bail application. I, the undersigned, Abashoni Parapara Ramikosi, do hereby state under oath that the facts herein contained falls within my personal knowledge and are to the best of my knowledge and belief both true and correct. I am an adult male person of 46 years of age and the applicant in these proceedings. I am a South African citizen and a holder of a valid barcoded identification document and currently reside at number 11A Henry Road, Rivonia, 2128 Gauteng Province. I consider the said address as my permanent address at Odomicilam Standi. I have been residing at the said address for more than 5 years. The said house belongs to me. I have been made aware by my tenure of record of the offences leveled against me and the seriousness thereof. I have been made aware by my tenure of record of the offences against me and the seriousness thereof. I wish to place on record that I will provide my plea when the matter proceeds to trial, should there be one. However, I submit that I will tender a plea of not guilty to the same. I'm confident that I will ultimately be acquitted of the aforesaid charges. I intend spending the trial until its finality in order to prove my innocence. Paragraph 5. My submission on the bail application. I'm advised that the offense for which I'm arrested for is a Schedule 5 offense. Thus, I would have to demonstrate that it's in the interest of justice that I be released on bail. I'm a qualified chartered accountant since the year 1998, having been employed previously by the South African Police Services as the Chief Financial Officer. I'm divorced to my wife since 2014, and we're blessed with 3 children, aged 15, 12, and 11 respectively. The kids are in and out of my house as we share a joint custody with my ex-wife. I own the following: a house, as mentioned above, valued at 3.2 million, and a Jeep valued at plus minus 624,000, and a Golf 4 valued at 60,000. I'm currently self-employed as a tax consultant, making plus minus 40,000 a month. I fully cooperated with the police when they came to arrest me. In fact, I personally handed myself at the offices of the Hawks upon hearing that they were at my house looking for me. I'd never and would not intimidate the complainants and or witnesses in this matter. More so, I do not even know the alleged witnesses the state intends calling. I submit that my continued detention will not be in the interest of justice, in that people who survive through my contribution will now have to be prejudiced. Thereby, in particular, my 3 children who solely rely on me for financial support. I submit that my continued detention shall lead to an adverse effect on my life and my family. I pray that this court assists me in returning my liberty and dignity and allowing me to be released on bail pending the final session of this matter. I submit that I shall stand trial until its finality, so that I will be able to prepare for the trying of this matter should it be so tried. If I were to be released on bail, this court would be promoting the constitutional principle of fair trial, in that I would be given an opportunity to properly prepare for my defense. I would also be placed in the similar position with the state to freely prepare and seek resources to aid my defense. There is nothing the state can bring to indicate that I may flight risk or that I will not stand the trial. I'm further willing to submit myself to the conditions of reporting to the nearest police station on dates and times this honorable court may order upon my release on bail. The nearest police station is... May I just approach the applicant just to make one amendment? Thank you, Madam. The nearest police station is SAPS Center. I am further willing to subject myself under Section 62 of the Criminal Procedure Act 2007 should the court order as such. If released on bail, I'll also be able to raise legal fees for legal assistance of choice in defending this matter and not be forced to take legal aid attorney. This should, however, not be construed as if I doubt the capabilities of legal aid attorneys, but that it will be an attorney of financial constraints and not of choice. At all relevant and material times to this matter, and more particularly during my arrest and detention, I gave my full cooperation to the police, including the investigating officer. I submit that the state would suffer no prejudice in my release on bail, and this would be in promoting the constitutional principle of being innocent until proven otherwise. Other requirements of the law. That's paragraph 11. I do not have any previous convictions, outstanding warrants against me. I've never violated any conditions set upon me. I have no pending cases in my name, except the current case to which I'm applying to be released on bail. Paragraph 12. In terms of Section 64 of the Criminal Procedure Act 1977, should I be released on bail, I will not evade my trial. I submit that I will not interfere with any witness should they become known to me at a later stage. Neither will I interfere with the investigation nor relocate or dispose of my assets in any way. I further submit that I will abide by any condition of bail granted by this court. I will attend court on any day called upon me to attend at 8:30 and stay in attendance until so accused by the court. It is my vehement that my release on bail will not undermine our criminal and bail system. Neither will same cause discomfort in the society. My granting of bail will not cause rage in the community. I submit that my release on bail will not jeopardize the security of the state and that I will not destroy or cause to be destroyed any state property and of any evidential material. I'm advised by my chain of record that the amount of bail is always in the discretion of the court. I'm further advised that the purpose of bail is to secure the attendance of the accused to the court, but not a fine. In this circumstance, an excessive amount of bail, which I will not be able to pay, will really defeat the purpose of bail. Looking at my posted background as stated above, it is my humble prayer that the court will not find it difficult to release me on bail in the appropriate amount. I humbly pray that the Honorable Court grant me bail. Properly signed and commissioned. If there's no opposition from the state, may the affidavit be admitted into record.
Do you confirm the contents of the affidavit as already identified by counsel?
That is the case for the applicant.
May it please the court, Your Worship, I confirm my appearance for the applicant in this matter, that is applicant number 7, Ernest Nesane. Your Worship, the applicant has prepared an affidavit, and I'd like to apologize for the affidavit. It's in a written form, a handwritten form, Your Worship. May I beg you to hand in the original, Your Worship. As the court pleases, Your Worship, in the regional court for the regional division of Gauteng held at the Specialized Commercial Crimes Court, Johannesburg, case number 48/2020, in the matter between the state and Ernest Nesane, the applicant. Affidavit in support of the application. Paragraph 1. I, the undersigned Ernest Tifelimbilu Nesane, identification number 7811035453-086, do hereby make the following statement under oath and say that I am a mayor-made person with the above identification number who resides at number 15 Kaku Crescent, Willow Acres Estate, Pretoria, and an applicant in these proceedings. 1.2. The facts herein deposed to fall within my personal knowledge and are to the best of my knowledge both true and correct unless the context hereof indicates otherwise. Where I make submissions of the legal nature, it will be so on the basis of the advice sought from my legal representatives and which advice I accept as correct. Paragraph 2, the background to this application. 2.1. I was arrested on Wednesday, the 17th June 2020 by members of the South African Police Services at the Pretoria Central Police Station after handing myself to them after learning that they were looking for me. 2.2. During the process of my arrest, I was informed that I am faced with the charges of 1. Racketeering, 2. Theft, 3. Fraud, and 4. Corruption. 2.3. For the purposes of this application, I must state that 2.3.1, I do not have any previous convictions. 2.3.2, there are no pending cases against me. 2.3.2, I do not have any relatives outside the Republic of South Africa, nor do I have any assets or property, be it fixed or movable, outside the Republic of South Africa. 2.3.4, I was born in the Republic of South Africa and can therefore safely submit that I am a citizen of the Republic of South Africa. 2.3.5, I am married to Onika Nesani in terms of civil union, and we are blessed with 3 children aged 12, 10, and 5 years respectively. 2.3.6. All the 3 children are still minors and are still at school. 2.3.7. At the time of my arrest, I was no longer employed but was assisting my wife in the running of her business. 2.3.8. In addition to the identification book issued by the South African Department of Home Affairs, I had a passport which was issued to me in 2008, and I am willing to hand same to the investigating officer in this matter for the purposes of this application. 2.3.9. I was never arrested, never admitted to bail, and therefore never skipped any bail or nor contravened any bail condition. 2.3.10. I do not know the state's potential witnesses to testify in the criminal trial against me, and therefore there are no chances that I am likely to interfere or influence with such witnesses. 2.3.11. In the same vein, I do not harbor any intention to interfere with the investigations in this matter. Paragraph 3. The charges leveled against me. I have been advised by my legal representatives that the charges as mentioned in paragraph 2.2 above fall within the ambit of Schedule 5 of the Criminal Procedure Act, Act 51 of 1977 as amended. 3.2. I am therefore advised that in terms of the provisions of Section 6011B of the Act, I have a duty to convince the above Honorable Court, and which honors is on the balance of probabilities that the interests of justice warrant for my release on bail. 3.3. I therefore submit that in the light of the factors highlighted above, I do not pose to be a danger to the society nor the criminal justice itself. 3.4. As the matter stands, I submit that the state's case is weighed against me, and therefore intends tendering a plea of not guilty to such charges should the matter proceed to trial. 3.5. I was also advised not to disclose the nature of my defense, as at this stage I do not have a full disclosure of the state's case against me. 3.6. I further undertake not to bring the bail system into disrepute, and therefore undertake to attend the criminal trial against me until such matter is finalized. Wherefore, I submit that I am a candidate to be admitted to bail, and therefore pray that I be released as paid for under the circumstances. Your Worship, the affidavit has been signed by the applicant in the matter. It has been initialed by both the applicant and also the Commissioner of Courts, Your Worship, as the court pleases.
Do you confirm the contents of the affidavit as read and read in the counsel? Accepted and marked.
As the court pleases, Your Worship, this constitutes the applicant's case, Your Worship, as the court pleases.
I beg leave to read the affidavit into the record. The Regional Court for the Regional Division of Gauteng held at the Specialized Commercial Crimes Court, Palm Beach, in the matter between Paulus and Duchenne Magula, which is the accused of applicant number 8, and the state, an affidavit. Either undersigned, Paulus and Duchenne Magula hereby make oath and state as follows. 1. I'm the applicant in this, an application for bail, and an adult male South African citizen aged 44 with the following personal particulars and background. 1.1. Identification number. My identification number is 760314546303. I attach a true copy of my identity document hereunto, marked as Annexure P in 1. 1.2. Date of birth. I was born on the 14th of March 1976. 1.3 citizenship. I'm a South African citizen. 1.3.1 travel documents. I have been issued with a valid South African passport. A true copy of my passport is hereunto annexed as Annexure PNN2. I will adhere to any reasonable condition of bail the above Honourable Court may deem fit to impose regarding the application and use of travel documentation for the full duration of this matter. 1.3.2 previous travel or residence in foreign countries. I have travelled to numerous countries for business purposes. I have visited Japan, the United States of America, Nigeria, Tanzania, and the United Arab Emirates. I have not travelled since 2018 though. 1.3.3 relatives resident outside the Republic of South Africa. I have no relatives resident outside the Republic of South Africa. 1.3.4 assets outside the Republic of South Africa, none. 1.4 personal background. 1.4.1 place of birth. I was born in Nchelele in Venda in 1976. 1.4.2 schooling. I attended the Patrick Romano High School. I matriculated in 1994. 1.4.3 tertiary or other training. In 1995 I commenced my studies at the University of Venda in Thohoyandou in the Limpopo province. I read towards a Bachelor of Science in Zoology and Biochemistry. I graduated in 1997. In 1998, I commenced with an honours degree in medical sciences, specifically relating to cell biology at the University of Cape Town. Subsequent to obtaining my honours degree in medical science at the University of Cape Town, I commenced with a bachelor's degree of commerce in accounting sciences. I commenced with the course in 2000 and graduated in 2005. In 2013, I successfully completed my honours degree in financial management through the University of South Africa. During the course of 2014 and 2015, I completed a master's degree in development finance at the University of Stellenbosch. 1.4.4 work history. In 2005, I commenced my employment at Alexander Forbes. I was employed as a pension fund bookkeeper. In 2008, I was offered a position at Deloitte, where I was employed in my capacity as a pension fund audit clerk. I was employed at Deloitte for approximately 3 years. In 2010, I became a business manager at Standard Bank. In 2012, I was promoted within Standard Bank to the position of the credit risk manager, which position I held for approximately 3 years. Since 1 August 2014, I was employed by the Public Investment Organisation, hereafter referred to as the PIC, as a credit risk analyst. I was later promoted and held the position of senior credit risk analyst. I was then again promoted to the position of acting head of risk. In 2015, I became the executive head of risk at PIC. By virtue of my position in the PIC, I was nominated to represent PIC on the boards of the following companies or institutions: the Trust for Urban Housing Fund, the Bachilo Hospital, the VBS National Bank, Makaya Housing, Daybreak Poultry Farms. I am, however, currently unemployed after I was dismissed by the PIC on the basis of performance-based issues. 1.4.5 General remarks regarding background and permanency. I've been residing in Gauteng since I commenced with my employment at Alexander Forbes in 2005. I'm currently married and I have 3 children. My family therefore ties me to the division of this honourable court. I've spent the most part of my professional career in Gauteng and I have no intention to relocate elsewhere. I furthermore do not have the financial means to flee, as I am currently unemployed and I have no inclination nor the means to live the life as a fugitive. 1.5 Current status. 1.5.1 Address. I reside at 11 Tain Avenue, Robindale, Randburg. I own this property. I attach here to a utilities bill marked as Annexure PNM3 in confirmation of this fact. I was also arrested at this premises by the police on 17 June 2020 at approximately 8. 1.5.2 Marital status and general particulars of spouse. I am married to Sandra Magula. In terms of customary law, we have been married since 2007. 1.5.3 Dependents. I have 3 children. I have 2 daughters who are currently 9 and 7 years of age. My youngest son is currently 1 year old. 1.5.4 Occupation. See paragraph 1.4.4 Supra. I am presently experiencing grave difficulties on securing employment. 1.5.5 Income from occupation. I currently have no income as I am unemployed. 1.5.6 Other sources of income. I have liquidated my pension fund in order to maintain my family for the time being or until such time as I am able to secure permanent employment. 1.5.7 Assets. I own the property I currently reside in. I own a 2006 Mercedes-Benz CLK 350 to the approximate value of 60,000 Rand. I also own a Mercedes-Benz C200, which is still the subject of an installment sale agreement. 1.5.8 Availability and sources of funds for bail. I can afford to pay bail in a reasonable amount. I do not, having lost my employment some 2 years ago, unlimited access to financial resources. I have available and can raise an amount of 15,000 Rand for bail. I cannot afford this amount to be forfeited to the state due to a failure to comply with the conditions of bail. 3. History of anti-social behavior. 2.1 Previous convictions, none. 2.2 Pending criminal cases, none. 4. Arrest and factual background thereto. 3.1 The date of my arrest. I was arrested on 17 June 2020 at my place of residence. 3.2 Offences charged with. I'm charged with the offences of racketeering, theft, fraud, corruption and money laundering. All these charges emanate from the so-called VBS bank fraud. 3.3 Intended plea. I intend to plead not guilty. 3.4 Defence. I've been informed of my right to remain silent at this stage and not to disclose the basis of my defence, and safe to deny all allegations preferred against me, elect to do so and to reserve the right to respond to whatever allegations the state may make during these proceedings. Submissions regarding the factors to be considered when deciding whether bail should be granted. 4.1 The schedule of the Criminal Procedure Act 51 of 1977, the matter resorts under. I have been advised that the offence that I am being charged with falls under Schedule 5 of the Criminal Procedure Act 1977 due to, apologies, Your Worship, that is an error. It resorts under Schedule 5 by virtue of the fact of the value of the amounts involved. I'll just correct that. Excuse me. No problem. Considerations in terms of Section 64 sub A to E. Danger to public and individual safety. I respectfully submit that my release on bail will not endanger any person's safety. I harbor no resentment toward any particular individual or to the public in general. I intend to stand trial in order to clear my name of these allegations. Section 64B, the likelihood of evasion of trial. I would respectfully submit that this likelihood does not exist. I do not wish to evade my trial and live the life of a fugitive. I furthermore do not have the means, financially or otherwise, to sustain such a life. I am willing to provide the investigating officer with my passport. I cannot afford to forfeit any amount that might be set as bail. Furthermore, I have lived in this area my entire professional life. I further undertake to adhere to any bail condition that the court may deem fit to impose. I interpose to mention that Advocate Terry Matau's report was published in or about October 2018. I was incriminated in that report and I was therefore aware of the fact that I might be arrested for this matter. Despite the aforementioned, I have made no attempt to evade the law. 4.2.3 Section 60 sub 4 sub C, interference with state witnesses or evidence. I respectfully submit that there is no likelihood that I would interfere with any of the state witnesses. I do not have any insight as to the exact allegations against me. I do not know what stage the investigations are at, and I furthermore do not have access to any evidentiary material held by the investigating officer. I have no knowledge as to the identity of prospective witnesses that the state intend to call, and in the event that their identity should become known to me, I would not interfere or attempt to intimidate them due to the fact that I intend to stand my trial and clear my name against any allegations that might tarnish my good name and reputation. Section 64D, jeopardy of functioning of criminal justice system or bail system. I would submit that I do not pose any danger to the functioning of the criminal justice system or the bail system. I have not furnished any false information at the time of my arrest or for purposes of these proceedings. Section 64E, exceptional circumstances, the presence or the absence thereof, which may lead to the undermining of public order or peace. I respectfully submit that there are no exceptional circumstances which may lead to undermining public order or peace should the court decide to grant me bail in this matter. The alleged crime against me has attracted media attention, but bail is, contrary to the public belief and opinion, not punitive in nature, and the issue of bail shall not be seen as some form of anticipatory punishment. I have been advised, which advice I accept, that this factor is not applicable to my application, but that legal argument will be proffered on this issue if the necessity arises. The provisions of Section 69, the interest of justice in relation to the right to be released on bail, I respectfully submit that I will be prejudiced in the event of being further detained, in that the conditions in prison are most appalling. In this regard, I request the Honourable Court to consider that I am not a flight risk and that I have no desire to abscond or to evade my trial, as it is my intention to stand my trial to clear my name. In the current circumstances of a worldwide pandemic, I submit that my continued detention will increase my risk to be infected with COVID-19. I further urge the court to consider the period I am to be detained until this matter reaches finalization, and the fact that the criminal trials can take a considerable period of time before being finalized. Apart from the fact that the period of detention cannot be estimated with any form of precision at the moment, I humbly request the Honourable Court to take into account that I will not be able to earn any income while so detained, and I stand to suffer considerable financial loss as a result thereof, will not be in a position to support myself or finance my defence. I further stand to face inevitable prejudice should I be detained for a lengthy period of time, that I will lose my ability to generate income as my ability to secure employment and my ability to earn may be adversely affected permanently. I also urge upon this Honourable Court that, should I be detained and refuse bail, that I would be severely prejudiced in the preparation of my defence. It is extremely difficult to consult with my legal representative from inside prison, and I have no doubt that my continued detention will seriously jeopardise my preparation for trial. Other relevant factors to be considered by the court: I respectfully submit that the interests of justice permit my release on bail, and that I am therefore entitled to be admitted to bail. As I have stated herein above, I do not intend to evade my trial. I have several factors that tie me to Gauteng: my relationship with friends in the community, and my social ties. I cannot conduct any business outside of Gauteng. I am not a flight risk due to the fact that I cannot afford the lifestyle of a fugitive. I am not in the financial position to be able to forfeit any amount that might be set as bail. I submit further that I am willing to abide by any condition the court may deem fit to impose. I humbly pray that this Honourable Court take into consideration that my arrest in this matter was imminent for some time. Speculation in the media has been rife as to when my co-accused and I would be arrested, and I knew that it was only a matter of time before a criminal prosecution would be instituted against me. I have not absconded or attempted to evade justice, despite the fact that I knew my arrest to be imminent. It is furthermore my belief, and I respectfully submit, that should this matter proceed to trial, I would be in a position to clear my name of these allegations, as I am confident that I will be acquitted of the charges. I respectfully submit that, taking into consideration separately and cumulatively the factors mentioned herein above, I have satisfied the Honourable Court that the interests of justice permit my release. In the premise, and taking into consideration the relevant schedule the charges resort under, I respectfully submit that the Honourable Court should grant bail to me in an appropriate amount and with such conditions attached as the court may deem fit. Thus done and signed at Palm Reach on the 18th of June. It's been duly signed by the applicant, and it's been commissioned as well, Your Worship. And then Annexure PNM 1 is page 11, PNM 2 is page 12, and then PNM 3 is page 13 and 14, which is the annexures to the affidavit. Just for reasons.
Do you confirm the contents of the affidavit as provided as amended to the this affidavit is accepted by this court and not
As it pleases the court, Your Worship, that's the applicant's case.
Thank you, my Lord. Your Worship, the investigating officer, Lieutenant Colonel Schneller, prepared an affidavit which I would request to read in with permission of the court. I believe it's the original copy is already attached to the charge sheet. Thank you. Your Worship, the affidavit should also be read with the indictment, which includes the detailed charges against the accused, as well as the allegations contained in the preamble, as well as summary of substantial facts. Thank you. I, the undersigned Louis Rolf Schneller, do hereby make oath and state that 1. I am an adult male employed as Lieutenant Colonel in the South African Police Services with service number 04266885-4, stationed at the Directorate of Priority Crime Investigations and attached to the Serious Corruption Investigation Component Head Office. The following facts to which I depose hereto fall within my personal knowledge and belief and are both true and correct unless otherwise stated. A. History. 3. I have been assigned to the investigation of the commission or suspected commission of offences as dealt with further below in the SAPS criminal investigation being conducted under Pretoria Central CAS 1058-005 of 2019. 3.1. The offences being investigated at this point in time in the above investigation and which are relevant to this application and which it is submitted are at least reasonably capable of being believed or suspected to have been committed as canvassed in more detail below are as follows: patterns of racketeering activities, fraud, theft, corruption and money laundering, contraventions of Section 4, alternatively Section 5, alternatively Section 6 of the Prevention of Organised Crime Act 1998. The nature, the nature, type of evidence and information acquired during the investigation so far that is relevant to the above listed offences comprises 4.1. The main allegation in this matter relate to the VBS Mutual Bank investigation, which was reported by Mr. Kuben Naidu, who is a Deputy Governor of the South African Reserve Bank. Year and after the complainant reported a case which was initially investigated with the DPCI Head Office Inquiry 7 of 8 of 2018 and ultimately converted into a case docket as per Pretoria Central Case 1058 of 5 of 2019. In his capacity as the Chief Executive Officer of the Prudential Authority, a juristic person operating within the administration of the South African Reserve Bank, established in terms of Section 32 of the Financial Sector Regulations Act number 9 of 2017. 4.2. The complainant formed an opinion that VBS Mutual Bank was in financial difficulties and as such would be unable to repay when legally obliged to do so deposits made with VBS. On 11 March 2018, the Minister of Finance, acting within the powers conferred upon him in terms of Section 81 of the Mutual Banks Act, read with Section 69 of the Banks Act of 1990, appointed a curator to VBS. 4.3. On 4 July 2017, the Board of Directors of VBS approved financial statements for the year ending 31 March 2017. The Chairman of the Board of Directors was Mr. Chifiwa Matotsi, whilst the Chief Executive Officer was Mr. Andile Mandlusi Atwell Ramavunga, of which both signed the Director's Responsibility Statement to the annual financial statements. The annual financial statements were prepared by the Chief Financial Officer, Mr. Philippus Nicholas Truter. The investigation has revealed that at the time of the approval of the annual financial statements by the Board of Directors for VBS, Matotsi, Ramavunga and Truter were all aware that the statement of financial position contained in the annual financial statements was false and that the complainant concludes that VBS was in truth insolvent at 31 March 2017. Investigations have further revealed that the DI returns that were submitted to the South African Reserve Bank, in brackets which form part of the attachments of the complainant's founding affidavit, closed the captions, were actually not a true reflection of the financial status of the bank. 5. VBS Mutual Bank was a mutual bank as defined in the Mutual Banks Act 1993. Further, that there was a relationship between VBS and a number of companies in which huge amounts of money are allegedly to have been paid into from VBS. Whether the relationship in terms of the directorship or any other form, on 13 November 2018, upon the application of the Prudential Authority, VBS was put under compulsory winding up by the High Court of South Africa, Gauteng Division, Pretoria. Mr. Anush Rupal was duly appointed on 14 November as a provisional liquidator for VBS, with the powers as set out in Section 3861 of the Companies Act 1973, read with Section 75 and 76 of the Mutual Banks Act and the extension order was granted by the High Court on 30 November 2018. 6. Huge investments were made with VBS by 20 different municipalities from 4 provinces. The investment by the municipalities of state funds into VBS and not a recognized institution caused them to contravene Section 173 of the Municipal Finance Management Act of 2003. Investigation has revealed that the said funds paid brokerage commissions to entities and to individuals to attract more deposits, mainly from municipalities. Tutu in his capacity, 7. Tutu in his capacity as Chief Financial Officer of VBS controlled and operated the banking system of VBS. Furthermore, Tutu prepared and of course to be prepared the annual financial statements that were signed by Matotsi and Ramavunga. 8. Mr. Poppy Mukobwane in his capacity as the Head of Treasury and Capital Management of VBS controlled and operated the banking system of VBS. Mukobwane controlled the financial records of VBS and prepared the returns in Section 53(1) and 53(3) of the Mutual Banks Act and as read with the regulations. On 17 July 2017, Mr. Sipho Malaba signed the Independence Auditor's Report for the audit of the financial statements, in which he gave an irregular audit opinion in respect of the annual financial statements for the year ending 31 March 2017. 10. On 1 October 2013, Mr. Falapala Avishoni Ramakosi was appointed to the VBS Board of Directors as a non-executive, and he remained in that position as at 11 March 2018. At all material times from 1 April 2016 to 18 March 2018, Mr. Ramakosi was the chairperson of the Audit Committee of VBS. On 4 July 2017, Ramakosi, in his capacity as the chairperson of the Audit Committee, signed the Audit Committee report as part of the annual report of VBS for the year ending 31 March 2017. 11. Mr. Ernest Nesani and Mr. Paul Magula, by virtue of their positions as directors of VBS, were entrusted with the oversight of the internal financial control system within VBS, and thus with the oversight of the receipt and custody of monies on behalf of VBS. Amongst the monies that were invested with VBS was an amount of 350 million invested by the Public Investment Corporation, PIC, in brackets, of which both Nesani and Magula were representatives of the PIC within VBS. In that both Nesani and Magula unlawfully, falsely, and with the intention to defraud to the prejudice of the PIC in circumstances where there was a fiduciary duty on them to act in the best interest of the PIC, failed to disclose to the PIC and to employees of the PIC that VBS offered existing VBS shareholders such as the PIC participation in the so-called second rights issue, where existing shareholders would be entitled to take up 2 shares for every 1 share held in VBS, and or of the existing VBS shareholders, only Valley Investments participated in the second rights issue, resulting in a dilution of the PIC's shareholding from 25.26% to 12% due to the non-participation of the PIC in the said rights issue, as Valley Investments became a 53% shareholder in VBS. B. The personal profile. 12. The first applicant is currently known as Chifiwa Calvin Matotsi. His identity number is 77071854068082, age 42, residential address 30 Green Street, Bryanston, Gauteng, work address, unemployed, assets. Applicant has the following moving assets: DG 66 JWGP, a Range Rover 5-litre Vogue, MASIND 2GP, it's a BMW X5 automatic, CY82DG GP, a white Suzuki, VDR 041 GP, a white Opel Corsa, WCT 308 GP, a black Land Rover, WVB 843 GP, a Swift trailer, BH13SH GP, a silver Volkswagen, and FM25NZ GP, a silver 3 Series BMW. His marital status is that he is married, is a citizen of the Republic of South Africa, and he has no previous convictions. 13. The second applicant is currently known as Andile Malusi Atwell Ramavunga, ID number 7910055362-084, age 40, residential address 401 Tilford Road, Cedars Creek, Neatwood, Fourways, Gauteng. Work address self-employed at the same residential address. His assets CX51DB GP, a white Audi, FH07ST GP, a black Land Rover, and NJJ227 GP, a green Alfa Romeo. He is married and is also a citizen of the Republic of South Africa. Also no previous convictions. 14 is the fourth applicant, is currently known as Poppy Londolani Mukodobwane, ID number 8411255281-082, age 35, residential address Unit 129 Bantry Road, Bryanston, Gauteng. His work address is he is unemployed. His assets are the following: movable assets CN04HNGP, a white Audi, FR02YCGP, a white Mercedes-Benz. His marital status, he is not married. Nationality is a RSA citizen. Previous convictions, also none of the on the known details of the applicant. The fifth applicant is currently known as Nklankla Calvin Sipu Mlaba. His ID number is 730505-6246088. His age is 47. His residential address is 708 Paddock Close, Cedar Lakes, Fourways, Gauteng. Work address self-employed at his residential address. His assets are the following: PRR523 GP, a white Toyota Land Cruiser, DC55RBG white Land Rover, THK071 GP, a black Ford, FF95 SFGP, a grey Mercedes-Benz. The applicant is married, is a South African citizen, apologies, and he has no previous convictions. The sixth applicant is currently known as Falafala Avashoni Ramakosi, identity number 7308035257-088, age 46, residential address is 11A Henry Road, Edinburgh, Sandton, Gauteng. His work address is unemployed. The movable assets known to him is BLM 219 GP, a blue Volkswagen Golf, DG26NV GP, a blue Jeep Cherokee, 003 PR GP, red Volkswagen Golf. The applicant is divorced. His nationality is a RSA citizen, and he also has no known previous convictions. 17. The seventh applicant is currently known as Tifalem Bilu Ernest Nesani. Identity number is 7811035453-086, age 41. His residential address is 15 Cuckoo Crescent, Willow Acres Extension 9, Pretoria, Gauteng. His work address is he is self-employed at the above residential address. The movable assets to his name is ZCL848 GP, a silver Volkswagen, FS81DT GP, a grey Ford Ranger, DX11ZD GP, a silver Toyota, NPS 688 GP, a white Toyota Conquest, XSJ768 GP, a white Toyota Quantum, and YXJ267 GP, a white Toyota Quantum. He is not married. His nationality is a RSA citizen, and he also has no known previous convictions. 18. The eighth applicant is currently known as Paulus Ndiceni Magula. Identity number is 760314 5463083. His age is 44. Residential address is 11 Tain Avenue, Robindale, Randburg, Gauteng. He is unemployed. The known assets are HG50FC GP, a white Mercedes Benz, and CJ89NW GP, a grey Ford. His marital status is that he's married. He's a RSA citizen, and he also has no known previous convictions. C. Reasons for not opposing bail. 19. The current matter against the applicants involve a Schedule 5 offence. The applicants will stand trial on serious and prevalent charges. The state has a strong prima facie case against the applicants. 20. The state has confirmed all the addresses of the applicants. 21. The state has set out strict bail conditions for the applicants, and the state is of the view that the control measures will suffice to monitor the applicants. 22. The state thus has no objection to granting the applicants bail in this matter and request the Honourable Court to take into consideration the bail conditions that will be tabled to this Honourable Court. 23. The commission of the statement by Lieutenant Colonel Schneller. He is present in court to confirm the contents if required, or answer any questions of the court. Thank you, Worship. I would then, will it be Exhibit H? I would request this Honourable Court to mark it as Exhibit H. Thank you. That's a case for the state, Your Worship.
Ek is nie baie bekend met hierdie proses. Gebeur nie iets elke dag. So wat het jy gesê? Wat is die vorm 7? Wat het jy gesê is
Die J7 was as hy
J7.
So hierdie
J7 is sy lasbrief wat hom tot 'n hegtenishouding.
Okay, maar
Nee.
Ja.
Kyk die
still possess a passport. Unfortunately, today it could not have been handed over to the state. It will, however, at the latest be handed over tomorrow. Your Worship, furthermore, my client is willing to report on a weekly basis at the closest police station where he will be residing in the area of Randburg. That is his new address, where he will be relocating to on the 26th of this month with his wife and children. Your Worship, I do not think that any other provisions or conditions rather must be set in place. I think that will suffice. Your Worship, and sorry, Your Worship, he, as also said out in his affidavit, he is located in Johannesburg. His family is here. He will not be able to go outside the boundaries of the Republic. I do, however, also know that he's got family in the Venda area, which is in the Republic, the boundaries. Your Worship, and
do we have to restrict ourselves to the boundaries of South Africa, to the boundaries of the provincial boundaries of South Africa?
I'll leave it in the court's discretion, Your Worship, but he's got family there. He needs people to support him. No one will be prejudiced if he will be allowed to go to the Venda province. But again, Your Worship, I'll leave it in the court's hands. Your Worship, while I'm on my feet, if I may, just one other aspect. As it is now, does Mr. Matotsi not have the bail amount break? So we had to make arrangements for him to be relocated to the SAPS where he was held yesterday, and that is in Midrand. So what my candidate attorney did was he phoned the station commander at Midrand police station in order to inquire whether they have the capacity to keep him there again. I have a letter from Mr. A. de Klerk, who is the commander at Midrand, confirming that Midrand cells, as requested, Mr. Matotsi can be remanded back to that police station. I beg leave to hand up this letter. Your Worship. Your Worship would have noted that there is no actual signature, but it is stipulated below in brackets originally signed by Mr. de Klerk. And I do submit that that will suffice under circumstances. Your Worship, no further submissions. As a copy.
As a President of the Court, Your Worship, if I may address Your Worship on the bail amount initially, Your Worship. As stated in the bail affidavit, Your Worship, we will abide by the court's order. I know that the prosecutor has mentioned the amount of 100,000 rand, and it has been discussed. We believe that an amount of 50,000 rand is also reasonable, Your Worship, as my colleague addressed Your Worship on. But should it be, should the court deem it fit that 100,000 rand is more appropriate, we will be able to raise those funds, Your Worship. That's the first aspect. I just want to mention yet again that my client has been sequestrated and it is subject to an appeal, Your Worship. So I wish for the court to consider that when determining the amount. The 2 passports, which my client is the holder of, has been provided to the investigating officer in this matter. It wasn't addressed in the bail affidavit, as it was only handed over to the investigating officer this morning. And we don't believe that it is necessary to have reporting duties at various police stations. I know that my client works in various provinces, including KwaZulu-Natal and Mpumalanga, Your Worship, so it would be to his detriment should he not be able to cross boundaries for that specific purpose, Your Worship. So my address is thus that the passports be handed up, Your Worship, but we can then continue to travel across provincial borders to continue with business activities, Your Worship. That is my address on the that point. Thank you.
The court is social. It should be now client's affidavit. We've made it clear the circumstances surrounding the amount. The amount of 100,000 has been indicated by the state. It's quite not unreasonable but unreachable amount. on the part of our client. Take into account that he's solely, for the past 2 years, has not been employed, and he's solely dependent on the family and friends who are assisting. And the amount of 20,000 rand seems to be a reachable amount by those who are assisting the client in this matter. Your worship, as to the conditions, client will not object to surrendering the passport, but with crossing provinces or changing addresses, client will always notify or will undertake to notify the investigating officer should there be any need of traveling between the provinces, whether Western Cape for consultation or inform or for seeing the family. Because even the place where he's currently staying, it is supported by the family. So, in all fairness to our client, if any higher amount is named, taking into account the situation with COVID, taking into account the situation with his cooperation to this matter, I mean, the police didn't have any problem to get hold of him, and he surrendered himself. He's really not a flight risk, and he's properly represented. The police will always reach out. So I think this is the discretion of the court that has to be exercised now. Just urging the court to be fair and be considerate so that our client is able to come back, properly present his case in this matter. Thank you. Not yet, but there was a discussion with an IO, and the undertaking was made that the IO must be handled. It's at home. Thank you.
Worship, the court will just allow me to quickly just address my client. Thank you. Your Worship, as stated in our affidavit of the bail application, my client can only afford 10,000 at this stage. Your Worship, any amount above that is unattainable for him. Currently, Your Worship, in order for him to make a living, he started a business a few months ago. His wife also started their own business, well, her own business. Your Worship, and to top it off, the lockdown did not really support business in this sense, Your Worship. So it is a bit of an economic tough time. Your Worship, the alternative that my client stated is the only thing he can offer is the one vehicle which he declared as movable properties in his affidavit as a form of security. But I would also just like to bring it back to the court's attention, or bring it under the court's attention regarding the fact that he's already handed in his passport. He's not a flight risk. The investigating officer is in possession of that. I'm sure he can confirm the same, Your Worship. Further, we made a submission, Your Worship, that he will sign in on a weekly basis, and if be, Your Worship, if it has to be on a daily basis, our client is willing to attend to that. and also to be confined within the Gauteng area. We understand, Your Worship, that it is at the court's discretion whether or not to grant this amount, Your Worship, but also we ask and pray to this court to take into account the fact that he does have minor children, he has dependent children. His wife, despite the fact that she's got her own business, that she started this own business, Your Worship, she's not on par to such an extent that she can truly carry herself and the children. Not only that, Your Worship, our submission was that our client does support his elderly mother, who's aged 71. But Your Worship, for him to be exposed to a situation where he's confined during this COVID pandemic, Your Worship, it would be to his prejudice. We ask that the court really consider the fact that he is willing to comply with any conditions set by the court, and to perhaps look at it might be 10,000, it might not sound a lot, but for him that 10,000 is much more than the court realizes at this stage. So that is quite hefty for him to pay currently. That's my submission, Mr. Court cases.
Thank you, Worship. Your Worship, I usually never take my colleagues by surprise when I'm in the middle of proceedings. I will confirm, Your Worship, that the issue of bail amount, my colleague did raise it with me, and he did suggest that the amount that was suggested to the court would be 100,000. Well, it's not that it's a lot of money, Your Worship, but the circumstances which faces my client are obvious, Your Worship, that he's not been working for 2 years, Your Worship, he's only involved in self-employed as a tax consultant. I'd not wish to hold this court ransom with suggesting this small amount or bigger amount, Your Worship. But if it pleases the court, not against what my colleague suggested, 100,000 would, 50,000 would be suitable. But if the court fixes it at 100,000, Your Worship, we will do our best to raise that amount so that the accused can be released. The other issues, Your Worship, are merely academic. I don't wish to repeat myself. It's obvious that he handed himself to the police, as the state is not opposed to his case. Passports have already been handed over to the investigating officer as requested. We had complied with that request. So, other condition, Your Worship, of reporting to the police station, Your Worship, I do not think that may be necessary as police court, unless if there's anything which the court would like me to address on. The passport has been handed over to the investigating officer already. I think.
Does the court resist, Your Worship? Before I address the court, Your Worship, may I please have a consultation with my client? I'm indebted to the court, Your Worship. The first issue to be addressed, Your Worship, is the issue about the passport. The applicant has indicated that he has a passport, but the passport is at the moment at home. I would submit, Your Worship, that the passport we can liaise with the state, that the passport be handed in to the investigating officer. And with regard to the amount to be set for bail, Your Worship, the accused indicates that he has been unemployed for a period of about 2 years, and then he has been relying on the income brought by the wife's business, which is in the tourism. And he also states that such business has been affected by the COVID-19, and the income had to shrink. And therefore, Your Worship, I would therefore suggest that the reasonable amount under the circumstances would be an amount of 50,000 dollars. And the accused also indicates that he has a family in Canada, but basically he is here in the Gauteng province. With regard to that, Your Worship, as a condition, I would leave that in the hands of the court, as a court case.
Bishop, I please call. Your Worship, in the circumstances, this is of course a Schedule 5 bail application, where the onus rests on the accused to prove that it is in the interest of justice that he be permitted to be released on bail. In circumstances where the state does not oppose bail, it is submitted that Your Worship may be led by the attitude of the state, which is in the circumstances reasonable in that they aren't opposed to bail. But apart from that, Your Worship, I submit that a proper case has been made out in the affidavit for our client to be permitted to be released on bail. The only issue that I feel I need to address, Your Worship, on is the bail amount, Your Worship, and a few aspects relating to the conditions that might be imposed by Your Worship. Firstly, Your Worship, bail is non-penal in character. The amount of bail that needs to be determined is not punitive in nature, and in the circumstances, Your Worship, it was held in the matter of State versus Fisher in 1975, which is Volume 2, South African Law Reports, at page 342 in the Cape Town High Court, that the amount of bail that needs to be imposed in a bail application does not need to serve as a deterrent for other offenders. Your Worship, in the circumstances, Your Worship needs to consider not only the seriousness of the case and the schedule of which it resolved under, but of course the personal circumstances of the accused in order to come to a just and equitable amount that can be set as a reasonable amount of bail. In the circumstances of this particular case, Your Worship, it's submitted that we cannot follow a generalized approach and say each and every single accused person should be released on the same amount of bail, especially in view of the state's affidavit, which clearly indicates that there is varying positions of involvement and that there are greatly different personal circumstances of each accused person in this matter, Your Worship. I've received instructions from my client that the family has only obtained 20,000 rand for bail. I submit, Your Worship, that in the circumstances, 20,000 rand is a reasonable amount considering our client's personal circumstances, Your Worship. In relation to the specific conditions that my learned colleagues has addressed, Your Worship, on, Mr. Magula has already surrendered his passport to Lieutenant Colonel Schneller in this matter. I do not think that reporting at the police station is necessary in the circumstances. The state clearly states in the affidavit that the control measures which they request will suffice for purposes of monitoring the accused persons in this matter. And the state has simply requested us to surrender our passports, which Mr. Magula has done. Furthermore, I don't think that our client should be restricted to the borders of Gauteng, but simply to the borders of South Africa. Our client his mother is currently 97 years old and she resides in Limpopo. So should the need arise for her to obtain any assistance in this regard, Mr. Magula might have to travel for those purposes. But we have no objection to the travel restriction past the borders of the Republic of South Africa. That's what pleases you, Worship.
Thank you, Worship. Your Worship, the decision to not oppose bail was not one that was lightly taken. The investigating officer considered all the factors that's relevant for us to satisfy ourselves that we believe that the accused will attend trial as required if bail is granted. And that's the ultimate purpose of bail, is to secure the attendance of the accused for the duration of the trial until it's finalized. We know that this is a difficult time with COVID-19 and that the prisons are overburdened, so that played a factor. So in the amount that we discussed with our the respective legal representatives of the accused, it was also not lightly or taken just from the pluck from the air when we discussed it with them. Our case is set out in the indictment that's attached to the charge sheet. If the court goes through it, the court will see that there are very serious allegations. The crux of the matter is that VBS suffered losses of 2.3 billion rand, almost 2.3, it's 2.296 billion rand. So the various thefts where the money was stolen are set out there. We also allege what each of the accused benefited. It's also set out in accounts. And if your worship will have a regard at the charge sheet, the allegations that we make is that the smallest amount of gratification that was promised to any of the accused was 5 million rand. And that's for the accused that's not in front of the court today. It is our case that all the other accused benefited more than that. So I know that the circumstances might have changed, but when we the amount that as we suggest is 100,000 rand. It might be a lot of money for people that don't have it, but given the circumstances of the accused, they are all professionals. They're all, at the time of the commission of the offences, held important positions. If the court have regard to where they live, the movable assets that they have, it's clear that they do not live a life of poverty, not any one of them. So it's our submission that 100,000 reflects on the one hand the seriousness of the charges on which they are going to be arraigned in the High Court, but it also serves as a proper guarantee for them to attend court as required. Your Worship, in addition to the amount of bail that we suggest, we also are going to request the court that as a condition, all of the accused must surrender their passports to the investigating officer. By surrendering their passports, we are also further requesting the court that they are not allowed to leave the boundaries of South Africa for the duration of the trial. That they also do not apply for new passports or travel documents during this period. Your Worship, all the suspects indicated in their affidavits that they don't know who the witnesses are in the matter. Our submission is that they through their legal representatives have been presented with the indictment. There is a list of witnesses attached to that indictment, that they do not make any contact directly or indirectly with those witnesses. Your Worship, if there are any additional witnesses that come to the fore, their names will be attached to the list of witnesses, and if we amend the list of witnesses, we will again circulate that to the legal representatives of the accused. Your Worship, that's our submissions regarding the amount of bail and the conditions. I don't know if there's any specific questions that the court have in addition thereto. Thank you very much.
All right.
The name is Hein, H-E-I-N. Van der Merwe.
Is it an R at the end of this? D-E-R.
V-A-N-D-E-R M-E-R-W-E. Like that, yeah.